Chief Justice recently said in the IEC v. Mhlophe case that every constitutionally permissible solution must be explored to avert a looming constitutional crisis. But he also cautioned that the court must never exempt conduct that is inconsistent with the Constitution from a declaration of invalidity, and flowing from that the court must never even inadvertently allow for unlawful conduct, that the rule of law must be preserved as we avert a constitutional crisis. The focus of Corruption Watch's submissions really go to how this court can minimize the potentially unlawful consequences that flow from this difficult moment that the parties find themselves in. We will submit that this court may and should order the extension of the 2012 contract for a limited period of time. And then we will turn our attention to the additional orders we hope the court will consider. Corruption Watch has noted with concern that many of the internationally recognized red flags or indicators of corruption are present in this case. And we have accordingly proposed orders to address these concerns. And our particular focus is on the procurement process and on SASSA's obligations in the procurement process. Our view is this court may and must extend the period of invalidity of the 2012 contract. We endorse the submissions of Mr. Unterhalter before us, that All Pay 2 lays the groundwork for that between paragraphs 52 and 59, where the court pointed out in particular that Section 239 of the Constitution, in defining an organ of state, refers not only to organs of state, but to any other functionary or institution that is exercising power in terms of legislation. That is CPS in this moment, and that is one of the sources for the court's power to extend the contract in the manner that's been discussed. Secondly, in response to the issues Justice Madlanga was raising, perhaps it is useful to think of merely as an analogy what our courts have said in the context of administrative decisions, where a contract or a period of invitation for bidders to submit tenders has lapsed or is going to lapse, and whether it is competent for the administrator in that instance to extend the period before it lapses. And our courts have held that once the date has come and gone of the lapse, there is nothing to extend. And at that point, there is no administrator, and we would submit no court, once the date has come and gone, that can extend something that no longer exists. But if this court makes that order of extension before 31 March 2017, it may lawfully do so. The contract still exists, albeit already unlawfully, but it is competent for the court to extend that period of, the period of suspension a little further. We further submit...
Ms. Steinberg, that doesn't deal with the problem that my...
She's protected until 22, according to that watch.
I'm happy to take the question. We say that the court should embark on this course of action because what it avoids is for the parties to make an arrangement that would otherwise most certainly be unlawful. It would prevent Treasury from having to approve an exemption that we know is unlawful must necessarily be unlawful. Treasury would then have to come and immediately review that decision on the authority of Kurland. We know it would be unlawful because the regulations simply do not allow for a lawful contract to be made between the parties in these circumstances. By extending the 2012 contract, this court will avert forcing government to embark on a course of action that it knows is unlawful. From Corruption Watch's point of view, the other virtue in this court ordering an extension of the contract is that it helps to bypass a particularly vulnerable moment in the procurement process. Transparency International categorized as special risk the moment of renegotiation between an incumbent contractor and the organ of state, because it necessarily happens without competition and in the dark, and where no one can test at that moment whether the terms of the extended or new contract are reasonable, particularly the price, but other terms as well. If this court extends the order on, extends the contract on the basis of its old terms, then the problems to which that red flag speaks are averted, at least for the moment. The parties are not put into a position where they have to negotiate new terms where one is being held over a barrel and the other doesn't have to account for those terms against competitors who might actually have better terms. Corruption Watch's concern, however, is that in doing so, this court must look forward to promote maximum accountability, transparency, and further investigation. Section 38 of the Constitution speaks not only of rights that have been infringed, but rights that are threatened. And we submit that we're in that terrain right now. And that perhaps is another source of this court's power as it orders the path going forward. We're in the terrain of rights that are under threat, the rights of beneficiaries, but the rights of the public too, who have a right to a lawful procurement process and to the public purse not being abused. The first set of orders for which Corruption Watch contends, which is Order 4 in our draft order, really go to ensuring that in whatever order this court makes, it doesn't immunize the process that has taken place and is going to take place from judicial review. Corruption Watch would like to see the SASSA having to file the Rule 53 record as quickly as possible so that the parties here and elsewhere can study those papers to see if and where a review lies. For example, in this instance, there might well be a competent review in respect of a failure to make a decision. Why didn't SASSA make a decision either to contract a new party pursuant to a competitive process or take on the process itself? We believe that that should happen in due course. It might be in the High Court, but that this court's orders, as we formulated them, could help facilitate and expedite that process. So that's the one set of orders for which Corruption Watch contends, with a caution to the court as it goes ahead and makes an order, perhaps extending the original contract, not to immunize any point of this process from judicial review. The second set of orders that for which Corruption Watch contends really speak to the red flags that have been raised. Corruption Watch is proposing that this court contemplate appointing 2 special masters immediately to govern the interim process and the process going forward. The first special master we see from the papers, the legal special master, the person who would supervise and report to this court as to the legal integrity of the process going forward. We see that SASSA has already asked and solicited the agreement of senior counsel. That's at paragraph 47 of yesterday's answering affidavit. And Corruption Watch endorses that and submits it should be made an order of this court. But in addition, a legal supervisor can do so much and no more. What seems to be crying out for additional attention here is an individual or group of individuals who can assist and monitor the technical and financial aspects of the process going forward. This court is not in a position to determine relevant prices, relevant terms. What it will require going forward is somebody to monitor and report in a fashion better than the fashion that SASSA monitored and reported before this court following All Pay 2. That process clearly isn't enough. SASSA managed to frustrate that court order, so merely repeating the terms of that court order, in our view, is just simply insufficient. There need to
My
be...
brother Justice Cameron has a question for you. The 10 minutes is up.
Thank you, Chief Justice. Ms. Steinberg, I want to return to the point that the debate between the Chief Justice and my colleague Madlanga with Mr. Untalter. And the submission is that we can extend the period of suspension of a contract which has expired, which expires in 16 days' time. And I find, as implied in the questions to Mr. Untalter, a certain incoherence in that. And I also don't think that Zondi applies, because when you declare legislation invalid, legislation has an open-ended prospective validity which you can impose an extended suspension on. But the nub is this: isn't it better for the court to say, to get to the outcome that you and Mr. Untalter and Mr. Badlander propose, to be candid and say we are imposing on CPS for a host of reasons a contract which did come to an end, but we're requiring it for profound constitutional reasons in the present emergency to continue for a specified period? Isn't that more candid than doing some very elaborate footwork about extending suspensions and so on?
Justice Cameron, in that formulation, would the applicable terms be those of the old contract?
Precisely. But then the court would be candid and would say we are not extending a period of suspension because the contract that was whose invalidity was suspended has gone. But we are, for overwhelmingly persuasive reason, requiring CPS to continue as a constitutional agent on the previous terms.
With respect, that is a more elegant solution.
I think it's less elegant than Mr. Untalter's, but it might be more candid.
From Corruption Watch's point of view, it would serve the purpose of avoiding the National Treasury from having to enter into what it knows to be, what it's been told by senior counsel would be an unlawful contract. And it would also, as I submitted earlier, circumvent that vulnerable moment of renegotiation. And from Corruption Watch's point of view, then either solution has those checks and balances and would suffice.
What is the fundamental legal difference in terms of legal basis between the two? Because what really worries us is do we have the competence to do it? And where do we look for the competence to do whatever it is we want to do?
Well, Chief Justice, in the first instance, further suspending the order of invalidity, I'm not sure why this court can't, before the 31st of this month, revise its order. There is an order and there is a contract to revise. And the court's power to do so would be the same power it had in the first instance, to suspend the period of invalidity.
Can you do so when we are aware that the contract is due to expire, come to an end on the 31st of March? Because that's a concern here.
Justice Mhlantla, I don't have a clear answer to that. The best analogy I could come up with was one in the administrative context, where as long as the order and the contract are extant, there is something to extend. If it's in the interest of protecting threatened rights, this court had said repeatedly it can craft novel remedies. I can't make any clearer submissions than that. The value of Justice Cameron's alternative is that it avoids that conundrum. And really, the question there, as I understand it, is does this court have the power to order a contract between two parties, one of whom is notionally a private party? For those purposes, we should perhaps assume that CPS is not a private party on the authority of All Pay 2, which says that for these purposes, we must understand it as an organ of state. And Section 239 says as much. For these purposes, it's an organ of state. So the question is, can this court impose a contract on two organs of state in order to avert a constitutional crisis?
Ms. Sternberg, what you and your colleagues will realize is that this is one of the difficulties that we have, and that is why we'll keep on posing the questions, and we hope some of your colleagues take notice and they will seize the moment to make submissions. You see, I need to know, and I think so do all of my colleagues, what is the legal basis that allows you to opt for one of the two, but does not allow you to opt for both, any one of the two that you may choose to? In other words, does the law permit you to only choose the option of, in quotes, renegotiating the contract or negotiating a contract or extending the contract, or does it also allow you to extend the suspension? Once we get the legal basis fine, then we'll exercise our choices easily.
Chief Justice, I'm not sure I can take my submissions any further than I have.
After all, you may not have come prepared for that question. It's something that we just thought through now.
We had not come prepared for that. What we are certain of is that the parties can't lawfully make that contract. We can't make submissions. At this point, at this level of consideration, we don't see a legal impediment to either of those two solutions.
May maybe come up with a lifeline, if I'm right. If accountability is indeed a central value of our Constitution, shouldn't we have regard to Section 195, dealing with public administration, taking into account the fact that CPS is an organ of state, and we consider the constitutional principles set out in 195, including that the people's needs must be responded to.
Indeed, Justice Nkabinda, I'm not sure that Section 95 provides the court with the source of power to order a contract, however. It speaks to the need for it, but I'm not sure that it founds the court's power to do so, if that is the question that's being asked. I'm not sure it makes it lawful.
Will that ever, supposing we are minded to extending, will we not consider those principles, even if we don't, in words, saying we are extending the contract?
Yeah, indeed, Justice Nkabinda. I think on either option, Section 95 must be taken into account.
Ms. Steinberg, I'm sorry. Would I be wrong to think that any of the two options which were put to you, any of them, has the effect of extending the contract? Either we say we're extending the suspension, on the other hand, which will have the effect of keeping alive the unlawful contract beyond its term. Or we say we're extending the obligation, but on the same terms of that contract. Isn't it the same thing?
The effect, Justice Jafta, is the same. It's the basis for that extension that differs. As I understand, the questions troubling the court is not the effect, but it's finding the proper basis to achieve that effect.
Yes, that's part of it, but one part of it is why would you have to choose one instead of the other if they have the same effect?
Well, is the court not going to have to say either we are further suspending our declaration of invalidity, or we are ordering the conclusion of a new contract that mirrors the terms of the old one?
That's true, but we can't do both. We have to choose one. So the issue is, what would be the basis of choosing the one instead of the other? But the overarching problem is, what is the legal basis?
Justice Jafta, I'm not sure that I can offer any more submissions. It strikes me that in the first instance, the contract was already unlawful in March 2014. This court had the power to, in effect, allow it to operate. And I wonder if it's not the power that court has to suspend a declaration of invalidity, if it's not the same source of power that allows it to extend that declaration of invalidity further, along with extending the contract. Either way, this court is in effect making a new contract because it would have died at the end of this month. That's unavoidable.
Yes, Ms. Steinberg? Your time is up. I don't know if you want to round up.
Until such time there is a new contract. Your prayer in para 4, is it still necessary?
Justin Plantler, we would submit that it is, in that what has happened so far is very troubling and is susceptible to review as long as this court doesn't close off that avenue. The review that comes to mind is why SASSA have failed to make a decision. And Corruption Watch's particular concern, the particular red flag that waves itself in this respect, is the question as to why the 2015 competitive bid process failed. In asking that question, we're also asking, was there in fact constructive contempt of this court order, or was there just genuine gross incompetence? We are alarmed that in the very first report that SASSA made to this court following the all-pay order, they presaged the possibility that their competitive bid process would fail. They said, this is on page 81, the first report to the court, which is undated. They said, in addition, as per the Constitutional Court judgment, if after testing the market through a new tender, the proposals emanating from this process do not offer appropriate or workable solutions or pose a risk to the timeous and regular payments of grants, SASSA is not obliged by the court order to award the new tender. And so it came to pass. What is also curious about that tender is that the price cap that was set in that tender was significantly lower to the price of the 2012 tender. Now CPS tell us that there are inflationary considerations and all other things that necessarily drive the price up over time. Why then did SASSA think that in fact the price could be driven down over time? Why did CPS not bid? Why did All-Pay not bid? Why did All-Pay spend 2 years in court to be able to bid and then choose not to bid? Now, what Transparency International's handbook tells us, as we say in our submissions, is that when an organ of state runs a tender process and it ends up with only non-responsive bids, there is a red flag of concern. Did it, crudely put, did the organ of state deliberately design a tender so that nobody could comply? Was it anticipating this crisis? Now, a proper review of the whole process as to why SASSA failed to make a decision, either to award a new contract through a competitive process or to become independently able to do it, we say is essential. Essential, but not enough. So Pref 4 goes to that. We say this in addition to that. This matter is crying out for investigation. We have the public protector and we have the hawks. The public protector looks into administrative malfeasance. We can certainly say at this point there's been administrative malfeasance. Why? What was the cause? Was it deliberate? Was the fact that this court's order was frustrated deliberate or not? These are questions to which the public deserves an answer. We, in addition, say there are enough red flags flying for this court to ask the hawks to at least consider an investigation into what happened.
Ms. Steinberg, let me ask you, some would argue, a dangerous question, but necessary. Because we have to make sure that we don't run into a crisis. With the knowledge that you have and the assessment of the facts, is there room for CPS saying the extension of the contract, whatever we want to call it, is going to ruin CPS financially? It is not a viable commercial proposition. We're going to have to fold up with the result that no services will be delivered. We won't be able to support this project financially. Project court of law, boom, liquidation, no services. Just assure us that that possibility is not looming in the horizon. Let me explain myself, just so that I don't keep on interjecting. These are 2012 tariffs. It's 2017. The rand was this strong. During that year, it has gone down this much. There's been one economic crisis after the other worldwide. We can't sustain this thing. Sorry. We respect the court order, but we simply are not able to do what the court says we must do. Just deal with that, please. Our order must be enforceable, eh?
Of course,
in reality.
Justice. Chief Justice, my learned friend mentioned that Allpay's expert thought that, conservatively speaking, CPS would be making a profit after year 2. Year 2. That they would amortize their capital outlay within 2 years. That was a finding of this court. It's not for Corruption Watch to, we're not in a position to analyze the numbers beyond that. Perhaps what this court could do, though, is reverse the onus, so to speak. If CPS, as an organ of state, is ordered to enter into a relationship for a short term, mind, and we're not talking about another 5 years, and there are 2 safeguards. The one is, at the end of the process, it can account for monies made or lost, and it can either hand back or be recompensed. There's no suggestion that this is a small start-up business that couldn't survive for the next year if it were not making a profit. There's no suggestion on the papers here at all. And if, after a proper, transparent accounting process has happened, there's been a loss over the 6 years, that can be rectified. But perhaps CPS can be invited in the order to come to the court to say, not before the end of this month, but to reverse. There's been an appalling lack of transparency here.
You see, I'm putting this question to you because lawyers, we are trained to reason in a particular way.
Yeah.
These are the papers. We must confine ourselves to the papers. And then a problem, a serious problem that nobody thought of, is not covered by the papers. You make an order by virtue of the powers vested in you as a court of law. Boom, boom, boom. People are simply not able to carry out that order because when you have the opportunity to raise the issue so that it's ventilated, you refuse to, and now you're settled with a situation where it's not possible to help the very people you sought to help, and those are the beneficiaries of the pension benefit. So I thought, just in case you and obviously your other colleagues are in a position to shed light that there is no impossibility looming in the horizon by reason of tariffs or price variations, you could make that input.
Chief Justice, could we not build into the court order that if it's necessary, CPS would have an opportunity to approach this court to vary that cap, that price cap? But then CPS must do the running, and in a manner that satisfies the requirements of transparency, etc. We could also possibly get the help of either the Treasury or an independent financial expert in doing that.
That would be a viable proposition if we retain some supervisory responsibilities as you and others propose.
Indeed, Chief Justice. And then I would submit there is an adequate safeguard to address the problem. If CPS throw up their hands and say, we're just going to run out of money, well, let them come, and then the court can amend the order accordingly. I dare not go beyond the papers because you will admonish me, Chief Justice, but that's as far as
I can go to beyond papers, and my colleagues can, if necessary. Yes. Anything else, Ms. Steinberg?
Just with regard to costs, Chief Justice, in Corruption Watch's draft order, we suggested that the costs be reserved, and the reason we did that is we share the view that it's time for individuals to account. And before we simply say the public purse can pick up the costs for this many rugby teams full of legal people who we see here, we should ask the individuals involved to tell this court on affidavit why they should not be held accountable for the costs.
Thank you, Mrs. Steinberg.
With the permission of the Chief Justice, may I just take you to paragraph 64? I'm trying to... 64 of all paid 2.
Of all paid
2. If beyond 31st of March, the contract would have been extinguished, what should we make of the last sentence of that paragraph, where the court says, but even after the dissolution of the contract, but before the appointment of another service provider, cash pay master will have a constitutional obligation. If we invoke what we said here, and using our 172 powers, will it still not be appropriate in determining a just and equitable order in the circumstances to extend the suspension of the declaration of invalidity now?
Justice Nkabinda, the short answer is yes, but it seems the court would have to exercise 2 powers. The one is to further extend the order of suspension, but that cannot bypass the need to further extend the life of the contract. Those are 2 separate acts. So on either solution, this court is going to have to extend the life of a contract which dies on the 31st. Either it does so as a fresh contract, or it does so by extending the old contract and then also extending the period of suspension of invalidity. But Justice Nkabinda, I think paragraph 34 precisely points to that dilemma. This contract dies at the end of this month, and the only way it doesn't die is if this court orders either that it is extended or that an identical one starts at the stroke of midnight. And that's a separate power with respect to suspending the suspension of extending the suspension of invalidity. I'm not sure if that's answered the question you were posing.
Thank you very much, Ms. Steinberg.
As the court pleases.